Ready, start. The High Court by impugned order condoned the delay and ordered for listing the second appeal for hearing on admission as well as application for a stay. Full stop. Learned counsel for the appellant submitted that the High Court had failed to deal with how single inverted comma sufficient cause single inverted comma clause had been shown by the respondent for condoning the delay comma more so when the respondent's review petition before the first appellate court was also dismissed on the ground of delay as they did not provide any justification for filing the review after a delay of over 2 years. Full stop. He contended that it is settled law that single inverted comma sufficient cause single inverted comma clause means that the party should not have acted in a negligent manner or failed to exercise due diligence. Full stop. Therefore, the appellant's argument that the cause of delay was due to COVID-19 cannot be accepted, as the respondent failed to remain vigilant, since the cause of action arose much before the pandemic hit. Full stop. With regard to the impugned order referring to the judgment in Shivraj Singh versus Union of India, within bracket 2023 bracket close 10 SCC 531, where it has been observed that courts must take a liberal approach regarding delays in appeals filed by the state, the learned counsel for the appellant drew the court's attention to paragraphs number 17 and 22 of State of Uttar Pradesh versus Satish Chand Shivhare and Brothers, 2022 SCC online SC 2151. Full stop. The explanation as given in the affidavit in support of the application for condonation of delay filed by the petitioners in the High Court does not make out sufficient cause for condonation of the inordinate delay of 337 days in filing the appeal under section 37 of the Arbitration and Conciliation Act. Full stop. The law of limitation binds everybody, including the government. Full stop. The usual explanation of red tapeism, pushing of files and the rigmarole of procedures cannot be accepted as sufficient cause. Full stop. The government departments are under an obligation to exercise due diligence to ensure that their right to initiate legal proceedings is not extinguished by operation of the law of limitation. Full stop. When consideration of an appeal on merits is pitted against rejection of a meritorious claim on the technical ground of the bar of limitation, the courts lean towards consideration on merits by adopting a liberal approach towards single inverted sufficient cause single inverted clause to condone the delay. Full stop. The court, considering an application under section 5 of the Limitation Act, may also look into the prima facie merits of an appeal. Full stop. However, in this case, the petitioners failed to make out a strong prima facie case for appeal. Full stop. Furthermore, a liberal approach, may adopted when some plausible cause for delay is shown. Full stop. Liberal approach does not mean that an appeal should be allowed even if the cause for delay shown is glimpsy. Full stop. The court should not waive limitation for all practical purposes by condoning inordinate delay caused by a tardy, lackadaisical, negligent manner of functioning. Full stop. Learned counsel for the appellant further relied on the judgment in Pathapati Shubba Reddy versus Special Deputy Collector, 2024 SCC online SC 513. Full stop.